stopped while I was, okay, yeah, perfect.
There we go.
Okay, thank you. Um, hey everyone, so my name is Julia Salafsky. I have brown curly hair. I am white. I have a beige sweater-ish thing on, and I use them they pronouns. And I am the co-president at the National Disabled Law Students Association. And I'm going to pass it off to Marissa to introduce herself as a co-organizer of this event tonight.
Hi, folks. My name is Marissa Ditkowski. My pronouns are she, her. I'm a white woman with dark hair that's pulled back and glasses, and I'm the executive director of the National Disabled Legal Professionals Association. And I will kick it off to Jamie, who is next on my screen.
Hi, everyone. My name is Jamie Strawbridge, he, him. I'm a white male with short, used to be brown hair and is now mostly going gray. And I've got a blue shirt on, and I'm an attorney at the law firm Brown, Goldstein, and Levy.
All right. I will jump in next. Hi, everyone. My name is Neil Lalchandani. I am also attorney at Brown, Goldstein, and Levy. He, him pronouns. I have short black hair, and I am wearing a blue collared shirt. And I will pass it to Rachel.
Hi everyone, my name is Rachel Lang. I use they, them pronouns. I am a white person with glasses on, brown eyes, and short, curly-ish brown hair in kind of a long mullet style at the moment. I'm wearing a patterned button down and a rust-colored blazer. And I am an attorney with the Oregon Law Center. I'm not here officially as any type of representation of the Oregon Law Center. I'm here in my own capacity as someone who has experienced attempting to get and successfully getting accommodations on a bar exam. Are we missing anyone else?
No, that's it. Julia, do you want to take it to the next slide?
Yeah, so the agenda for this webinar tonight is we're going to start off by, this is Julia speaking, by the way, start off by introducing what NDOLPA does and NDOLSA, which is National Disabled Legal Professionals Association, and NDOLSA is the National Disabled Law Student Association. And then we'll give a brief, Neil and Jamie will give a brief overview of what Brown, Goldstein, and Levy do. And then we're going to dive right into Rachel and talk with them about their experience with the bar and accommodations, navigating high stakes with a disability. And then we'll actually go through a presentation with Neil and Jamie on the legal principles behind the accommodations and what you can do and some tips and tools. Marissa, would you like to kick it off with introducing NDOLPA?
Sure. This is Marissa. So the National Disabled Legal Professionals Association is a 501c3 as of this year. So we are relatively new. We're a national association of disabled lawyers, judges, policy experts, legislators, academics, and other legal workers and professionals that strives to promote professional growth and opportunity for disabled attorneys and legal professionals, improve access and inclusion in the legal profession, and ensure access to justice for all. So we do that in a couple of ways. Number one, we provide direct support to disabled folks who are experiencing issues in the workplace or have questions. We also support the National Disabled Law Students Association and the law students and answer their questions as well and try to support them in navigating situations that are very difficult to deal with, and we provide referrals to lawyers as necessary. We also put on events like this one, create resources, and much more. So happy to be a resource to any of you who have questions, and thank you so much for joining tonight. And I will kick it to Julia to talk a little bit about NDOLSA, and then we will just level set a little bit before we get started.
Yeah, so NDALSA, National Disabled Law Students Association, is a student-led 501c3. And by student-led, I mean that everyone is a volunteer who's either a student or a recent graduate, which means within the last like 2 or 3 years. We are a sister organization of NDALPA, and so we advocate to reduce the barriers to law school and we improve the experience of disabled law students within the school. And more specifically, we use a disability justice lens to strive for meaningful access, not just accommodations, but a meaningful opportunity to participate in whatever practice you want. Just because you're disabled, we believe it doesn't mean you have to be a disability justice warrior. The idea is that anybody should be able to become a lawyer and do so without barriers. And I think that that goes into us leveling the topic for today is to recognize that accommodations for the bar, the MPRE, is difficult. It is not fair. It is not an equitable process. And so, although we ultimately believe that high stakes exams are ableist and that we should dismantle them, we believe in providing these tools for everyone for now to at least be so that everyone can succeed at least with what we have at this moment. And that's why it was important for us to bring in Brown, Goldstein, and Levy and Rachel to talk about this and help you guys out.
This is Jamie. Let me just talk briefly about Brown, Goldstein, and Levy. So Brown, Goldstein, and Levy, where Neil and I work, we are a civil rights firm and we're headquartered in Baltimore, Maryland. And we have a nationwide disability rights practice, which means that one of the core focuses of our firm is to represent people with disabilities across the nation to break down unlawful barriers and make sure that people with disabilities have equal access. And we do that in a lot of different areas. We bring cases in the healthcare sector with respect to voting, education, and of course, also testing accommodations, as we'll talk about in particular tonight. But our practice is broad and it's one of the real priorities and specialties of the firm where Neil and I work. I think we can go on to the next slide from there.
All right, and now we're going to have Rachel, you can add on to your introduction and also just talk to us about your experience with high stakes exams.
Sure. So again, this is Rachel. Should I read through my bio or was that was already sent to everyone?
It was sent to everyone. This is Julia, but so it's up to you.
Okay. Well, I'm a staff attorney at the Oregon Law Center in the Hillsborough Regional Office. I advocate for low-income individuals across 5 counties in Northwest Oregon. Like I said before, I am not here on behalf of Oregon Law Center in any way. I'm here on my individual capacity, but in my own practice, I do specialize in housing discrimination, public benefits preservation, and education law. I deal with a lot of disability law within those areas. I frequently provide legal education presentations to community partners, staff our legal clinics across the coast, and staff a public benefits legal advice hotline for the state of Oregon. That's a joint effort between the 2 legal aid organizations. I took the bar exam in 2020, which was enough of a task in and of itself. The bar always is. But the bar exam kept getting pushed back. My accommodations were initially denied because of a mailing issue where they said they didn't receive my accommodations in time, or my application for accommodations in time. They had not published anywhere easily visible or put in any emails that they had that already allowed for online upload of the application. So, and the printed materials that were available on their website were saying that you had to mail, that they would only accept mailed applications. The applications had to be notarized, so I had to track down a notary in the height of the pandemic. Like, this is before masks were available, so it was, it was the lockdown. I was in New York City, which was like fully locked down for quite a while. There were a lot of barriers that I was facing. And then, they decided to switch the bar exam to be online, and I need a paper exam. So that was a whole ordeal attempting to get the paper exam. I had to request reconsideration again. And request new accommodations I never had to request before, because suddenly I needed a paper exam, which wouldn't have normally been an accommodation at that time. And uh, throughout the whole process, I was in constant communication with a lot of my other disabled law student friends who were facing similar issues. We were all sharing resources, drafting letters together, drafting our request for reconsideration together, sharing information we found out about why certain things were happening the way they were. I wouldn't have been able to get my request for reconsideration in on time without the help of my friends at that time. So that was very helpful. Highly recommend sticking together with your friends and reaching out across the organizations. I ultimately was able to successfully request reconsideration. I guess technically one was reconsideration and one was a request for additional accommodations. And then I had to make a third request because right before the bar exam it was like a couple weeks before the bar exam was scheduled. They let me know that I was to be taking the bar exam in person in Times Square at a hotel in October 2020. And I have a disability that causes me to have severe light sensitivity and sound sensitivity. So Times Square is probably the last place on earth I ever want to go. I avoid it at all costs. And I had to let them know that, like, you should read what you accommodated me for, because please no. And in much more formal language. And then I was able to get that approved. They let me take it at my apartment. They delivered the paper copy in a locked like box. I felt like a spy with this like fancy box that they delivered. And then they like called me with the code each morning to unlock the box so that I could take the bar exam. And I had to open it on camera and do it in front of the screen. And I was, watched by the video thing the whole time. I'm sure it flagged all of my movements and several disability related things, but I passed ultimately. So it all worked out well in the end, but it was a rough time.
Yeah, this is Julia. I was wondering if I could ask you for regarding like self-advocacy. What do you think is it knowing that it's a traumatic thing to do? Like self-advocacy is hard. I mean, we all have to do it every day and it can be very emotionally laborious. So what is some advice do you have for students who might need to engage in some self-advocacy for this process?
Yeah, I have a lot of tips on that. The biggest thing that I like to like recommend, and the thing that worked the best for me, is I uh, someone told me this too, so I can't even take credit for this, but I treated myself as I would a client. So I created a timeline of deadlines I had to make, and like, everything you would for a client. And then I tried to, like, it's obviously impossible to fully do this, but try and remove myself, my like emotional attachment from like the injustice of it all and the experience I was going through as much as I could, and try and figure out, why would they be denying, what basis would they have to deny anything? And any arguments I was making in any of my requests. I like thought through any like counter arguments they could make and then already addressed them in my letters. They were all very long. And like I said, I crowdsourced, so relied heavily on my friends. You know, it's very likely that you're not the only one going through this. And there are people out there that can help. So those are my big tips. Treat yourself like a client if you can. Um, and yeah, reach out for help.
This is Julia speaking. Yeah, I find that when I haven't done the bar, but for MPRE, it's really hard to get myself to write it, even though I advocate for students all the time. So I'm definitely going to try your advice where I treat myself as the client or see if that might help or reach out to my community. I guess outside of the bar, I think it's like a good thing to remind people that the horrible experience at the bar, that this horror stories we hear is not just everything. So what is something you celebrated after you passed the bar that feels good to you?
Like non-bar related that I celebrated.
Yeah, I guess career related, not bar related though.
Oh, okay. Well, I was really excited when I got this job at the Oregon Law Center. I worked for a firm for a period of time before this job, and the work I was doing wasn't what I wanted to do. It was just the only job I could get during the pandemic. And there are a lot of little victories you find, especially if you work in a legal aid type setting. There's a lot of need out there, and a lot of places where you can make a difference. And it's often in the least expected situations that you find that those little victories. So even if it's, you're turning someone away, but they then say that like talking to you made them feel better, little things like that. I've had some like actual victories, but I feel like those situations end up almost feeling more meaningful. And moving to Oregon was also something that was really exciting for me. Like I said, I took the bar in New York. I wasn't intending on living in Oregon at the time. My friends who were in Oregon got diploma privilege and didn't have to take the bar. So a lot of my peers were very lucky in that situation. I was a big advocate for diploma privilege. Yeah, moving to Oregon too.
Awesome. This is Julia. I'm going to hand it off to Marissa to wrap up this part. Thank you so much, Rachel. That actually was really helpful. And feel free to chime in as the presentation goes along too.
Yeah, this is Marissa. Thank you so much, Rachel. And folks, the Q&A is open. We will check it throughout, but we will probably mostly answer questions at the end, unless it's something we could type, but feel free to use the Q&A. Rachel makes such great points about community. We take care of each other, and that's why Indulsa and Indulpa exist. We want to make sure folks don't have to reinvent the wheel and that we leave things better than where we are right now. So please feel free to reach out to us if you need us. We are here for you. We are here to support you and to support each other. And I will kick it to BGL for their portion.
Okay, thank you so much. This is Jamie again from Brown Goldstein Levy, and I also thought that was a great presentation from Rachel, so thank you. And the power of community, both of those things are really hit home with me. So this slide is sort of an intro slide. It says Brown Goldstein Levy and has our logo at the top, and then it says applying for accommodations on high stakes exams, which is the topic of the day. So maybe we could go to the next slide, Julia, please. Just a brief agenda for today. We're going to talk about the purpose of testing accommodations, then examples of testing accommodations, eligibility for accommodations, a Department of Justice guidance on the issue of testing accommodations, and then the application process. So the purpose of testing accommodations, I'm going to read a quote first. Testing accommodations are changes to the regular testing environment and auxiliary aids and services that allow individuals with disabilities to demonstrate their true aptitude or achievement level on standardized exams or other high stakes tests. So that's from the Department of Justice guidance that we'll talk about in a minute. But just to set the table, that's what testing accommodations are. And I suspect the people on this Zoom already know that, but they're changes to the testing environment or other aids or services. And it's all about making sure that the person taking the test can show their true aptitude. You know, that's the purpose. Next slide, please, Julia. So this slide has some examples of testing accommodations, and there are many different possible types. This is not an exhaustive list, but some of the testing accommodations that exist and may be appropriate can be Braille or large print, exam booklets, screen reading technology to access information on a computer, read it aloud, extended time, stop the clock breaks, distraction-free rooms, permission to take and bring medications during the exam. There's all different types of accommodations, and it depends on the individual. This next slide deals with eligibility for testing accommodations. So to be eligible for an accommodation on a high stakes test, the requirement is that you have a disability. And under the Americans with Disabilities Act, that's a broadly defined term. So an individual with a disability is a person who has a physical or mental impairment that substantially limits a major life activity or a major bodily function. So life activities, seeing, hearing, learning, reading, concentrating, thinking, and then major bodily functions, endocrine, digestive. There's many different types. And the definition of disability under the Americans with Disabilities Act, it's very broad, and that reflects congressional intent. When the ADA was passed in 1990, Congress did not want a lot of back and forth about whether someone has a disability. It's supposed to be a broad term that brings a lot of people along to make sure that they're not stopped by unlawful barriers. Next slide, please.
All right.
I'll pass it over to Neil. Go ahead, Neil.
Thanks, Jamie. So this is Neil. And I actually want to just start off before I discuss this slide, kind of echoing something that Julia said and that Rachel touched upon, which is really the injustice kind of this entire process, and just want to, acknowledge that. I mean, the bar exam is in many ways, a hazing ritual for everybody that bears little to no connection to kind of actual practice and succeeding, as a lawyer. It's an artificial test across so many different areas, and when you're in practice, that's not really the mode of how people work. And then to layer on top of that, the kind of excessive burden of documentation, oftentimes expense, stress. So there is, that is unfortunately a reality. And part of what, we do at Brown Goldstein and Levy, and I think the value that we can provide is, taking on some of that burden and obviously recognizing that, legal services are itself a barrier for many folks. But I just wanted to kind of acknowledge, that up front, and hopefully through this presentation, we can provide some additional tools for that self-advocacy, and also happy to kind of connect with people after the presentation to help kind of as best we can. So with that prelude, I'll get back to the slide, which is an excerpt from this really important kind of legal document. This is a guidance from the Department of Justice, specifically the Disability Rights section of the Civil Rights Division. And this is a technical assistance guide that was first published in 2015, and it was updated in 2020. and still is very much in effect. And this is the Department of Justice's kind of own interpretation of all of the ADA's requirements in this arena. So it is entitled to deference. And when we, take on these cases, this is something we cite heavily and we rely on heavily. And as Jamie mentioned, kind of the guiding principle is that the exam should reflect an individual's aptitude rather than impairment or disability. And we have seen so much, I think, of an overcorrection, not only for bar exams, but we represent folks for the MCAT and SAT. And there's kind of this knee-jerk reaction to deny people accommodations. There's so many misperceptions in this area as I've experienced it. And one of the most common and most kind of pernicious is that, people are trying to game the system. They're trying to get an extra advantage. And I have never seen that in dozens and dozens of cases. But that is kind of what is, I think, motivating a lot of the testing entities. And this guidance from the Department of Justice is one tool to push back. So now we're going to talk about some of the key principles. And the first is really one principle that's reflected in that guidance is there really should be this respect for a history of prior accommodations. And that history can take, different forms. It can be on prior standardized exams. So for one example is, if you're seeking accommodations on the bar and you received accommodations for the MPRE, then you should have a really strong argument in that you should receive accommodations for the bar. Despite that, I've seen a number of cases where people have had MPRE accommodations and then are denied for the bar, and that really makes no sense because the accommodations have to be tailored to a particular setting. And I think most everyone would agree, bar exams are longer, typically more complex, denser exams. And so depending on the person, but in most cases, if you have accommodations on the MPRE, you have a stronger rationale for accommodations on the bar. The history of accommodations is not only limited to prior standardized exams, but can be from, 504 plans, IEPs, from schooling earlier in life. And there's also a recognition in our cases that, people's circumstances change. Some disabilities, of course, are lifelong. Others can affect people differently at different times. And some kind of have onset later in life. And there's also this category of informal accommodations. There's kind of we are aware that not everyone is necessarily diagnosed or provided accommodations, earlier in life, even if they require them from a very young age for all sorts of reasons. Could be financial, it could be stigma in a particular community, it could be awareness. And so a history of informal accommodations, meaning even sometimes we have students who said, well, in elementary school, I would ask my teacher, can I stay in during the lunch period? And that history under the DOJ guidance, even if it wasn't formalized, is entitled to respect. So that's the first key principle. The second on the next slide is just as there's kind of a deference and respect for history of accommodations, there should be a deference to evaluations that are completed by clinicians who have personally evaluated the applicant. I imagine that some, if not many of you, have undergone some sort of kind of evaluation from a clinician, and these are, oftentimes very detailed, rigorous. Some cases, depending on the disability, multiple days, and that should be entitled to respect over the testing entities who just conduct this paper review. And really, we oftentimes argue that the person who's just reviewing, first of all, they have a huge volume of cases and they're really looking kind of in evaluating with an eye towards exclusion, which is the opposite of the principle that Jamie was just talking about. But this is key. There's this key of deference and also another kind of flaw that these testing entities rely on, and you might see in denials, initial denials, is they're so focused on the data depending on the disability. So certain metrics to the exclusion of kind of the history, the behavioral observations, family history, interviews, all of which should be part of a holistic review of someone and whether or not they require accommodations. And that all goes into, a qualified professional's evaluation. So that's another key principle reflected in the Department of Justice guidance. I saw a question in the chat about, kind of when do you start the process for applying for accommodations? And, that's really dependent on which jurisdiction you're in. We had done a presentation actually with my colleague who's barred in New York, and she wrote here, typically 4 months before the exam in New York. And I should say that there's an image here of, the specific application that the New York State Board requires. And as Rachel was alluding to, there are, can be separate deadlines that are not always, readily apparent. And in addition, specific requirements of, what is required. Some jurisdictions, for example, require personal statements. Some jurisdictions require testing within a certain time frame. And I believe in New York and other places, there are specific guidelines. So I'm kind of just straining my eyes a little bit to see here, but there are guidelines that it's referring to depending on if it's a learning disability, ADHD, physical and chronic health disabilities, etc. So it's really important to look at those specific guidelines that might govern in any particular place.
Hey, Neil,
This is
there you go, Marissa's
Oh,
gonna.
sorry. This is Marissa, just to kind of chime in on the deadline piece. I know I answered that in the chat as well, in the Q&A as well. But for accessibility, I'm just going to add, 4 months might be the deadline for when you need to apply. But I would recommend applying as soon as you know that you are taking that exam in that particular jurisdiction. Because you might, even if you meet the deadline, you might get a response from the bar too late to actually appeal. And the longer you wait, the better the chance of that happening. And so for your best opportunity to course shift if you need to, or to appeal or anything like that, I would just recommend applying as soon as you're able.
That is an excellent point, because sometimes the testing entities will also come back and say, you need to provide this additional documentation. And I think Marissa and I might have been talking a couple months ago about something that we had noticed was happening in DC for the bar exam, which was, even though I had clients who applied right when the application opened or very soon after, DC was waiting very close to the actual bar exam and then releasing decisions in batches, mass denials, leaving folks with very little time to, seek their reconsideration or appeal, which, I think was an intentional tactic on their part, but definitely echo that.
This is Julia. I would add too, for the MPRE, go ahead and do it as early as you can as well, because the MPRE, for example, my accommodation that was mostly everything denied except like one variation of something, I would have only had 2 days to use the approval to register for the exam that I wanted to. And so I think that if I had applied earlier, I would have gotten an decision earlier, but that's also still not guaranteed.
Yeah, and that actually made me think, Julia, too, of, I've had clients sometimes who've been denied accommodations for the MPRE, and they think, well, I might be able to pass the MPRE without accommodations, but it's worth appealing or pushing back, because you can build that record so that when you get to the bar, for example, you'll be in a better position. So I think we can go to the next slide, which is just some examples of documentation. And there really is a requirement that you should not be obligated to provide more documentation than necessary. And which is not always strictly followed, unfortunately. But different types, you can learn more about this in the DOJ guidance. One thing I just want to flag, so in addition to the standard forms of documentation like reports and obviously proof of prior testing accommodations, this is sometimes an area where you can be creative. So I've had clients who, for example, have obtained letters, obviously from teachers or maybe from a tutoring center on campus, but even in some cases from parents or family members who might be able to explain, why accommodations weren't sought earlier in life. Sometimes we use transcripts to demonstrate kind of a before and after pattern of, students who received accommodations. They might be able to show, a noticeable increase in their performance after receiving accommodations. And then you can make this compelling argument that this is a reflection of my true aptitude in line with the standard. So there are some ways to kind of be creative with what you provide in addition to the standard materials. We can go to the next slide, which always gets my blood pressure up, which is the common reasons for denial. So there's a list of 5 reasons on the slide. And these are reasons that we see over and over again. Actually, not just from bar exams, but I don't know if all these testing entities talk to one another. In many ways, the MCAT is one of the worst that I've seen. But the common rationales are that folks, have not substantiated their disabilities, or some cases, the entity will say, well, you are disabled, but not severe enough to warrant accommodations. And on that point, we sometimes see partial grants and partial denials of accommodations. And if you're in that situation, I really would encourage to push back, because we use that against the testing entity in a way, which is, well, you recognize that the student has disability that warrants accommodations, but then you're second guessing kind of the level of accommodation. So that is one area you can push back on. Some things we were just talking about, another common reason as well, you didn't have testing or didn't have a history of accommodations earlier in life. And kind of the logical gap there as well is like, well, just because you didn't have accommodations earlier in life doesn't mean that you didn't require them, or circumstances might have changed, as we discussed. And number 5, which we'll talk a little bit more about how to push back, is something I see all the time, which is that the student has achieved kind of an average or an above average score, sometimes in their coursework, sometimes on evaluation testing. And so the testing entity says, well, this person therefore cannot be disabled and warranting accommodations, which is, in many ways, the most problematic rationale, this idea that, someone with a disability can't achieve these scores. And there's some really good law in this area, which I think we have later on in the presentation. So we can move on. This is a slide on appeals and reconsideration. And Rachel kind of helpfully talked about, some of the different, there was kind of a request for an additional accommodation. Maybe there was a reconsideration as well. There's different terminology that's used depending on where you are. In some cases, you're seeking kind of just a straight review again of what you've previously provided, the materials you've already submitted. In our cases, we really do recommend as much as you can to provide supplemental evidence. And this again is infuriating because it shouldn't be necessary. And a lot of times our letters proceed in 2 parts, where we say the initial materials that were submitted were way more than sufficient to justify the accommodations requested. But even then, here is even more materials. So here's an updated personal statement. Here's an additional letter. Sometimes the clinician will see the denial and will have a response to the rationale used. One area that I see folks have some success with is in cases where you have multiple disabilities, the testing entities don't always appreciate the cumulative impact of multiple disabilities. So for example, I've had clients maybe with ADHD and generalized anxiety disorder. And so that's something you can highlight kind of in additional supplemental materials. Okay, we can move on to the next slide. And these are just some basic kind of guidance points, which are steps to take in an appeal or reconsideration scenario, referring to the DOJ guidance, updating a personal statement, supplemental evidence, and assistance of a lawyer, unfortunately, in many cases does make all the difference, because I've seen entities take things a lot more seriously once a lawyer has been involved. We can move to the next slide, please. And this is a slide on how to respond to some of the most common arguments that we were talking about. And we'll provide, I believe the slides have already been provided, and we'll send it out to folks who haven't yet received them. So I don't need to kind of read these word for word, but I'll just highlight some of the key points of, especially if there is a lack of prior history, providing that context is important. And really, for if there's a disregard of clinical findings, oftentimes we see there's kind of cherry picking that the testing entities use, where they might say, oh, here's one small portion from the clinician's report, and they do that to the exclusion of 5 other pieces of evidence. So just kind of as kind of a lawyerly skill of pointing out what was missed is helpful. We can move on to the next slide. And here's some of the law. This is responding to the argument that, oh, because there's an average or an above average score in some area, therefore accommodations aren't warranted. And there's a case that we refer to, and there's also regulations on this point, that it's really about shouldn't be judged based on outcome, based on test scores, but on the process that an individual uses to achieve those results. And this is a key principle. And something else that we can highlight in our letter is, if you have kind of had compensatory measures that you use to achieve results to kind of mitigate your disabilities as much as possible, you can provide some of that context, because you shouldn't be judged, again, just based off of outcomes, but based on the effort and the process that goes into achieving those outcomes. So there's a cite here on this slide from the Bartlett case, which is out of New York, and I find that to be a very helpful case on this point. So I'm going to pass it back to Jamie just to round out a few slides for us.
Neil, and I know we want to get to the Q&A. So the slide right now on the screen is just talking about our law firm's disability rights practice. Again, for those that have interest, as Neil mentioned, the slides will go out. And Julie, if we could go to the next slide, this is something that I just wanted to highlight briefly, which is that even if you get past the high stake exam and you get a job that have always dreamed of, some of these issues continue to arise over and over again, including in the workplace. Not having a welcoming enough environment for people with disabilities, people not getting accommodations that they need in the workplace. And so I just wanted to briefly mention that at our firm, we also have a consulting arm called Inclusivity Strategic Consulting. And that's all about consulting with companies and government entities to make sure that they are inclusive with respect to people with disabilities. And we do that through a variety of vectors, education. We do a lot of work in the education sector. We do a lot of work with governments, and we work with sort of soup to nuts to make sure that these employers understand how they can create a supportive, inclusive, and welcoming environment for people with disabilities. So I just wanted to highlight that quickly, and then I guess we have some time for questions.
Thank you all so much. I learned a lot, took a lot of notes for myself, by the way. And this is really, by the way. Marissa, will you be able to read out? And anybody who wants to answer, just go ahead. Rachel, I'm sure you have things to add